Chapter 7 discusses pretrial procedures and the trial process. So one thing that's really important is to think about how defendants are processed, and this begins from the moment they're arrested for an alleged offense until they're convicted, sentenced, and are serving time for their crime. How this process happens can be the basis for an appeal or a legal challenge to a higher court. What's happening here is we need to make sure that when we convict somebody and when we arrest them that we do this according to due process. Due process basically means that we're following the rules of the game. So first we're going to start with an arrest. And an arrest usually means that we've taken an offender into custody. And usually these arrests are made by a police officer. Arrested people are often referred to as arrestees. So depending upon whether you committed a misdemeanor or a felony, officers have to have at least reasonable suspicion in order to stop and detain somebody in order to investigate them for committing a felony. If after that process has begun, the officers have probable cause to believe the suspect have probably committed the alleged offense, then the officer can arrest them, take them into custody, and take them to jail for further processing and identification. Once someone's been arrested, they've been taken to the police station, they're going to be booked. Booking's an administrative procedure. It's where we get the personal background information about the person who's been arrested, and we place this into the person's file with the police station. So this would include everything from your height, your weight, your eye color, any identifying marks, any aliases, etc. Once you've been booked, the next step is going to be an initial appearance. And so that is exactly what it sounds like. It is your initial appearance before the magistrate. This is a formal proceeding during which the magistrate or some other type of judicial official is going to advise you of the charges against you. And this follows the booking process. Whenever a crime has been alleged, it's important for defendants to be advised of the charges against them. You certainly cannot defend yourself if you don't know what you've been charged with. Whether or not you have a right to bail varies. Okay, under early English common law, basically bail was a right, and this has been incorporated into our formal laws. So the right to bail is in our Bill of Rights, and we are protected from the right against unreasonable searches and seizures, double jeopardy, self-incrimination, grand jury indictment, trial by jury, and the right to bail. These are all rights that we have under the Bill of Rights, which is the first 10 amendments to the Constitution. So bail is basically a way that you guarantee that you're going to show up for court, okay? It's a surety. Bail bond is a written agreement, a written guarantee. So a bail bond is generally accompanied by some type of money. Maybe it's accompanied by a deed to some property. That the person charged with an offense will remain in the court's jurisdiction to show up for their trial at some future date. Some states allow for bail bondsmen. These are people who either own or are working for a bonding company. Bonding company is someone who's authorized to post bail for people. So usually what happens is you pay 10% of the bond to the bail bond, and then the bail bond puts up your entire bail. So basically what happens is you lose that 10% no matter what. And if you skip out, then the bond company is going to be authorized to come after you for the remainder of the money. So under the 8th Amendment, citizens are advised that excessive bail shall not be required, nor excessive fines imposed. The 8th Amendment also deals with prohibitions against cruel and unusual punishment. But there are some criticisms here. So the bail process generally discriminates against the poor. So a lot of times there are people who have bail that's as low as $50, $100, $200, and they can't post that. If you can't post bail and you remain incarcerated pending your trial, you're less able to help your attorneys with your defense, and you are much more likely to be convicted. Race, gender, and socioeconomic status have been among things that we've looked at to see how they impact bail decision-making. These are things that should not impact the bail decision because they're extra legal variables. They don't have anything to do with whether or not you're going to show up for court. But research does tell us, as I just mentioned, anybody who is detained, so anybody who is not released on bail, they're much more likely to be incarcerated, convicted, incarcerated, and to serve a longer sentence. So it's actually really important that should you be arrested, that you're able to post bail. So in 1984, we had a Bail Reform Act, and this gave magistrates and judicial officers greater autonomy in setting bail and releasing people on their own recognizance. That's often referred to as ROR. It's basically that you have enough connections to the community, ties to the community, that the court believes you will show up. And so you're basically released on your own reputation. Several states have passed sexual predator laws targeted at violent sex offenders, which automatically deny them bail. Okay, so we've made it through, we've been arrested, we've been booked, we've had an initial appearance, maybe we've been able to post bond, and the next step is going to be a preliminary hearing. This is basically where the judge or the magistrate is going to determine whether or not there's probable cause. Right, so probable cause is the likelihood, how likely it is that you have actually committed a crime. This is a relatively low threshold to meet. Your case may then go before a grand jury. Not every case goes before a grand jury, and not every state uses them. But grand juries are groups of citizens. Massachusetts, I believe they serve once a week for 3 months. And what they do is they hear evidence from the prosecutor, and they determine whether or not to indict somebody. If they do decide to indict them, they return what's called a true bill. If the true bill is issued, then they face arraignment on the charges against them. If no bill is issued, then they're discharged and the charges against them are dismissed. It's actually super easy to get a true bill in a grand jury because the prosecutor is allowed to use evidence in the grand jury that they wouldn't be able to present in court, in trial, and the defendant has no right to appear and probably might not even know that a grand jury has been convened. So our next step is an arraignment, and this is basically where we're going to enter our plea. Okay, we could plead guilty, we could plead not guilty, which is probably the most common plea, or you can enter a plea of what's called nolo contendere. Nolo contendere means no contest, and it's treated the same as a guilty plea. The benefit here, though, to pleading nolo contendere, or no contest, is that there's not an admission of guilt by you on the record. And so this can't be used against you if you were going to be sued, for example, for the same behavior or the same incident. So as I mentioned, guilty plea is the equivalent of confession. Judges are usually expected to inquire whether or not the plea is voluntary and to make sure that the defendant understands the charges against them and the consequences of choosing to plead guilty. Not guilty means then that a not guilty plea means the judge is going to set a date for trial. At this point, the judge could review bail and determine that bail will be continued. Or they may permit somebody to remain ROR'd. We just talked about what a nolo contendere plea is. So the trial process is pretty rare. It's somewhere around 95% of cases are bargained out. But a trial could involve either a bench trial, so that's where the judge is both the trier of law and the trier of fact, or a jury trial. Speedy Trial Act, this is a federal law, and so it doesn't apply to the states. But in a case where someone has pled not guilty, the trial has to begin within 70 days from the date when either they were indicted, so indicted by the grand jury, a true bill was issued, or an information was filed. And this is just a different way of indicting somebody. It's basically where the prosecutor just files an indictment with the court. Unless the defendant waives this right, trial shall not commence, so trial shall not begin less than 30 days from the date on which the defendant first appears. So, as we mentioned when we talked about jurors, a jury trial begins with the selection of a 12-member jury. Again, it could be a 6-member jury. And a bench trial is a trial by a judge. So, in a jury trial, the judge tries the law. The judge rules on what's admissible, what's not admissible, how the law applies. And in a jury trial, the jurors decide on the facts. In a bench trial, the judge is both the trier of law and the trier of fact. Anyone charged with a felony is guaranteed the right to a jury trial. So if you're charged with a misdemeanor, you do not get to demand a jury trial. The jury will hear your case and decide guilt or innocence based on the facts presented. If they're going to find you guilty, they need to do so beyond a reasonable doubt. Okay, so we've made it this far, and now your trial is going to start. Both sides are allowed to make what's called an opening argument. An opening argument and closing arguments are not evidence. Okay, this is basically where both sides are going to lay out their story, their version of events. Then the state presents its case first, and this is because the state has the burden of proof. It's the state's job to prove you're guilty beyond a reasonable doubt. It is not your job to prove that you are innocent, although you probably should try to do that. Each witness that's going to testify is going to be sworn in by the court officer. And that's basically where the witness is saying that they're going to be truthful. And this is termed direct examination. So direct examination is if you are a witness for the prosecution is questioning you. If you're a witness for the defense is questioning you. Once you've been questioned, then you're going to be cross-examined. The other side is going to try to make you seem not credible or poke holes in what you've said. Then what can happen is what's called redirect. So we can come back and the person, whichever side you're a witness for, can come forward and ask questions. However, they can only deal with things that were brought up on cross-examination. Same thing for recross. So you've gone through redirect. Now the opposing side can come back at you, but again, only to address things that came up in redirect. So one of the things you want to try to do is you want to try to impeach a witness, okay? And impeaching a witness means that you have called their credibility into question. We can do this in several ways. We could do this by somebody says they saw somebody do X, Y, Z, and if we can prove that they wear glasses and they were at a far distance and they didn't have their glasses on, or that there wasn't a clear view from where they were standing, we could basically impeach them that way. We also have what's called eyewitnesses and expert witnesses. So eyewitnesses are generally lay witnesses. They're just going to attest to things that they have observed with their five senses. Experts, however, are allowed to give an expert opinion, and they have some type of qualification. So experts would be people who testify about blood samples, firearms, ballistics. They might be talking about whether or not someone's mental health has played a role in their crime, and they're allowed to give a professional opinion. Many states also have victim witness programs. So if you are either a victim or a witness in a crime, you may be assigned a victim witness advocate. They're going to notify you of what's happening in the court system and help prepare you for that. They might also, if you are a victim, help connect you with victim witness assistance, which is where you might be entitled to reimbursement for costs related to your victimization. One area that's received a lot of attention is children as eyewitnesses. So we have a lot of children who are victims of crimes, and in particular, in regards to sexual abuse, a large number of children are abused before the age of 12, and nearly a third of them are under the age of 6. So testifying in court for anybody can be traumatic and difficult, but certainly if you're a child, it could be a lot worse and a lot scarier for you. And parents of sexually abused children often don't want them to testify in court. Once the state has proven their case, then the defense attorney can make a motion for a directed verdict. They can basically say to the judge, look, the prosecution has not proved their guilt, proved their case beyond a reasonable doubt, and they can ask the judge to dismiss the charges at that point. This doesn't really happen. So usually what happens next is the defense puts on their side. So they're going to do the same thing. They're going to call all of their witnesses. They're going to be cross-examined. Potentially there's going to be a redirect and recross. Defendants, however, do not have to testify. And if a defendant chooses not to testify, the jury is not allowed to take that into consideration in terms of whether or not that means anything about their guilt or innocence. This is a guarantee provided to us under the Fifth Amendment. Fifth Amendment provides that we do not have to be compelled to incriminate ourselves. And while the jury is going to be told that, hey, you can't take this into consideration, the reality is that the defendant may believe that if the jury may believe that if the defendant doesn't testify, that they have something to hide. So after this has happened, prosecution and defense have both presented their final arguments, which are going to be closing arguments, going to be similar to opening arguments. The judge is going to give the jury instructions. What do they have to find in order to find this person guilty? Then they're going to retire to a jury room where they're going to deliberate and arrive at a verdict. So jury voting in U.S. district courts and federal district courts, the juries consist of 12 people. The judge may or may not permit the selection of alternate jurors. These are jurors who are listening to the case, and if anything happens where an actual juror needs to be dismissed, an alternate juror can step in. In federal courts, the decision has to be unanimous for guilt or acquittal. In state courts, Supreme Court guidelines says juries may vary in size from a minimum of 6 to 12 people. The Supreme Court has established the minimum number of jurors at 6. So after the jury's deliberated, they're going to come back into the courtroom, and the defendant's going to rise and face the jury, and the foreman or the judge is going to read the verdict. If the verdict is not guilty, the defendant is released. In the event that the jury has come back with a guilty verdict, the defendant has a right to appeal that. All appeals, however, have to be based on errors made in law, not on your innocence. If the judge does not grant a defense attorney's request to put the verdict aside, then the defendant's going to be sentenced. The appeals process takes many, many years, and you cannot appeal directly to the Supreme Court. And in fact, the Supreme Court hears very few appeals. So basically, what we're going to be doing here is you're going to go through your state process. And that wraps up Chapter 7.